Any mention? Item number 1.
Your eyes are very good.
Mr. Lordship, Lordship, I am trying to grant some accommodation to argue this matter, Your Lordship.
What review you want this matter?
Lordship, actually, there are two things where genealogy tree
1 second,
annexed.
file come to my brother. Yes.
Genealogy tree annexed by the respondent before the learned single bench, and also in my affidavit before the learned single bench. There is two separate genealogy tree. They are claiming that that particular account belongs to Moment, but my claim in the annexure, the document which I submit, it actually belongs to Marak. So that is the whole thing. And then we said that in the affidavit we have clearly stated that mentioning that respondent
when the appeal was heard, was that brought notice of the court?
No.
Then was it brought notice of the court? This document you're referring to?
Yes, it was brought before this honorable court, Your Lordship.
For review, we'll dismiss it.
Your Lordship,
see, Mr. Sangma, this judgment of this court, which is taking review, was passed in 9th of February 2021. Correct?
Lordship.
Now we are in 26. That apart. This is the writ appeal that was filed in 2012. And the petition was filed in 2004. So now 2004 to 2026.
No.
So what you want to unsettle now?
Lordship, actually,
2004.
that person who was pursuing the case, Your Lordship,
judgment was passed. 2004 writ petition was filed.
Yes.
For some reason, judgment was passed till 29/11/2010. The appeal was 2012. Now you come review. Then the matter is disposed of in 21. Now in 26, it's seeking review. Lordship,
that's why in my miscase application, Lordship, I have mentioned that person, the late grown-out, was pursuing the writ petition as well as the writ appeal. He expired while the writ appeal was still pending. Therefore, the wife, due to ignorance of law, there was no communication as such, even with regards to the disposal of the writ appeal, Lordship. That's why I have even mentioned, because that person...
What bearing will it have on the outcome of the appeal? Suppose the wife was, suppose he was dead or alive, what bearing will
now, actually, there were two writ, I was the respondent, there in this...
Remember, this year, seeking review writ appellate order. Okay.
In fact, the entire case is based on the new FIR, filed by the petitioner, which was filed, which was lodged on 5th August 2025. That's the main basis of this review,
No, Lordship, actually we are...
They have filed an FIR, a report was submitted by the police. Now on the basis of this report, they are coming before this honorable court.
Anyway, no grounds are here for review, the same dismissed case.
Hello,
Lordship, kindly grant me some time.
Item number 2.
Hello,
Yes.
Item number 2.
What's wrong with the video?
Lordship, there was a specific direction of this honorable court for the appellant to file the substantial question of law, but till date they have not filed it.
Where's the appellant? Nobody is here.
This is the fourth consecutive day non-appearance, and then they have not filed the substantial question of law also.
Mr. Pandey appeared earlier on. Now Mr. Pandey says that he's been divested of that responsibility. Where's Mr. Pandey? There's no appearance on behalf of the appellants today also. However, in the end of justice, same is adjourned just after 2 weeks.
3.
Apply, sir.
Item number 3.
Lordship is connected matter, Your Lordship. It's connected matter, Your Lordship.
Okay, after 2 weeks.
Really obliged, Lordship.
4.
I think it's from the wind affected. Yes.
Yes, last time I have submitted justification for substantial question of law with a copy to the other side also. It has not been framed by this Honorable Court.
Where's Dr. Mozika?
He's engaged in courtroom
The
number
thing
1,
is that why not been framed, because Dr. Mozika said that there are no substantial questions of law. So they have a small hearing on that. Whether there are any substantial questions of law to be framed at all.
So another thing, my lord, my client has informed me that he will change the advocate. So sometime maybe given.
Change with advocate.
Yes,
Or he'll change you.
yes. So let me hand over the file to him. 2 weeks time maybe given.
Yes. This is for 3 weeks on the prayer of Mr. N. Gupta.
5.
Okay, much obliged.
Please, Your Lordships. I'm praying for some more time to file our affidavit.
This is who's for a petitioner?
Mr. S.K.
Who's the
Saha.
case Saha?
He used to come through VC, Lordship.
This won't do now. This company is in Shillong. This is phone number. The notice to the respondent number 5 return unserved with the how can I refuse simple court direct access? Can be with the notice been refused. Not understood as how an authority such as the Central Board of Indirect Taxes. Why are you not appearing for them also?
We don't have instructions, Lordship.
Pura. This is 17. No? This is 18. See what I can do. Oh yes, you take the step on it. 63 again. This was 132. Then again, this is dated. 26, 25 to 3. Second refuse.
Sure. Before that,
Is the right address or not? Somebody refuse. Deemed service. Can you face the consequences? Yes. Yes, stop. It is noted that this is the second time that the one of the 5 has refused to accept notice. Accordingly, this one shall stand deemed served, and the matter will proceed. Yes, Adnan appears for the Petitioner this after 2 weeks.
6.
What's wrong with this tax?
Connected
One
matter.
appearance.
Similar
6.
matter, Lordship. Item number 6 as well.
60 matter
Lordship.
after 2 weeks, yes.
Highly obliged.
May I please say lordships? And therefore item number 5 and 6.
After 2 weeks, they'll file affidavit
Highly
also.
pleasure.
You'll file affidavit in the meanwhile.
7.
After 2 weeks, 1 on 4 to file affidavit in the meanwhile, yes. Yes.
7.
On behalf of DGFT,
Yes.
I am appearing on behalf of DGFT, Your Lordship, respondent.
What's DGFT?
A Director General of Foreign Trade, Your Lordship, on behalf of the respondent side.
Which item? This
7 and 8, Your Lordship.
SD Ceramics, yes.
As this ceramics, Your Lordship.
Yeah, Mr. B.N. Gogoi.
Lordship, Dr. B.N. Gogoi.
Yes, Dr. B.N. Gogoi. Where's the affidavit?
Lordship.
Where's the affidavit?
Lordship, we supposed to file, but there is a technical difficulty in the registry, so we need 1 week time again, Your Lordship. We are supposed to file today itself, but there is a technical difficulty of the format of the registry in the Meghalaya High Court format, Your Lordship. I beg to apologize for 1 week time, Your Lordship.
Okay. As per for the 2 weeks time allowed by affidavit. By respondent 1 and 5. 1 to 5. Yes.
Hearing.
Obliged.
Hearing 9.
Deeply obliged, sir.
Yes.
My lord, my esteemed colleague Mr. Paul is supposed to give reply and let it AG.
Mr. Kriyam, give reply.
Yes, Your Lordship.
The limited issue here, as your lordships would have seen, whether a procedural error insofar as notification of a certain law by the district council will per se render it ultra vires of any provision of the constitution. That's my limited understanding of this particular matter. And my humble submission as as your lordships are aware, that per se non-followings or non-adherence to the said procedure may not by itself render the law illegal. So that is what
No, but if the prescribed procedure is not followed,
deviation from the procedure.
deviation is whether, see, what is, I think this case, if I correctly remember, was sent back to the district council for inserting certain amendments, correct? And that was done by
Without placing it before the house.
That was never placed for the house then.
True.
So we have to maintain that position only. So it cannot be a valid piece of legislation.
No, my humble submission is that per se will not render it invalid in view of the fact that it was subsequently notified. It received the assent of the governor and it was notified in the official gazette. Had that not been done, of course the position would have been different.
Limited, you give your answer in that limited aspect. Yes. Whether it was not placed for the house, but however received whether the governor's discretion.
What had happened here is
that extent.
What had happened in this case is.
Yeah.
Initially it was sent, the governor returned the bill for consideration of certain objections that were raised by the petitioner's side.
Yes.
Now, in the meantime, the District Council Affairs Department made a communication to us. There was a typo error when the bill was forwarded from our end to the governor, the Honorable Governor. And that is why, but that met with a logical end because the matter was sent back saying that kindly consider this particular objection which has been filed by the respondents. Matter rested at that. In the meantime, the District Council Affairs Department issued a communication to us. Now that communication, would find that page 40.
Page 40.
Mallet.
Who is the petitioner, Mr. Changresi? Who is he?
The two petitioners are there, my lord.
Yes, who is he?
My lord, they are the resident of the Himamar.
Not an aspirant for CM.
No, not aspirants, but this act will govern them.
Yes, Mr. Paul.
No, my lords, he's the first is the secretary of the Dorbar Hima Maram Semship, and petitioner number 2 is Mintri, my lords.
So they have enough locus.
So, my lords, at page 40,
Yes.
my lords, your lordships will see this is a communication dated the 25th of August 2023. This is from, my lords, the secretary of the District Council Affairs Department.
Yes.
The District Council Affairs Department, my lords, writes that with reference to the letter on the subject cited above, I am directed to say that the Law Department of the Government of Meghalaya, after careful examination of the bill, has made the following observations. That the proviso at clause 2 of the bill may be omitted as the principal act so-and-so has been enacted only to provide for the procedure for nomination and election of the CM, Deputy CM electors of Hima Maharam and to look after the day-to-day administration of the village and not for land administration. The proviso to clause 3 is in order. The figure 1 needs to be omitted. So insofar as the second part of it is concerned, I don't think there's too much of a difficulty. This was a clerical thing. Only issue is, Millets, if I may draw your lordship's kind attention to the proposed bill, Millets. Millets, if my lords, can I have page 27? My lords, 1, 2, 3, 4, 5, 6. 6 lines from the bottom. If my lords kindly see, there's a proviso to section 2.
You provide in right, yes.
Provided that in rights also impair, the act shall apply in matter relating to village administration only and not to land regulation.
Yes.
So this is what has been omitted.
Okay.
In terms of the letter of the district council, this is what has been omitted. Now I must take your lordships to the AD rules, the procedure that is prescribed under the rules. Here are the rules.
As a copy, ano to yun? Ato naka-act onto the hasil. Yes.
Well, it's it would all start from
29.
Rule 72 onwards, Millets.
72, sorry.
72 onwards. 72 is where the power is to be exercised, Millets, and where they are permitted to make law with regard to matters enumerated in subparagraph 7 of paragraph 2. And then, Millets, if we can come to Rule 92, Millets.
Yes.
Well, it's when a bill has been passed by the district council, the secretary shall, if necessary, renumber the clauses, revise and complete the marginal notes thereof, and make such purely consequential amendments therein as may be required, and a copy of the bill shall be submitted to the chairman and shall be signed by him and the governor to for assent. After the bill has been signed by the chairman, the secretary shall sign an authenticated copy to each of the following: to executive committee for information, to the governor for information through the secretary, district council affairs department, government of Meghalaya, if the bill does not require the approval of the governor, being not so specified in any of the provisions of the 6th schedule, to the governor for approval thereof, if it is required under any of the provisions of the 6th schedule of the Constitution of India. Now, Malad, 93 is important. When a bill has been passed, is submitted as in Rule 92(2)(3) and is returned by the governor with a message to the district council for reconsideration, the point or points referred for reconsideration or the amendments recommended shall be put before the council by the chairman.
This is what this court is saying.
Here, what I'm saying is there is no message from the governor.
It amounts to message the governor will be from the district council.
No. Why, I will say is because of this. Why I would say is this, if I may just draw your lordship's attention.
just bear with me for a moment. Let's, if I may draw your lordship's attention to page 35 for 34 minutes.
Yes.
34 minutes of the writ petition.
Temporary chairman.
Governor Secretariat, well, it starts with Governor Secretariat. Annex 6, page 34.
Oh, page 3 of the writ petition.
Now, let's kindly see, this starts with Governor Secretariat.
Yeah.
Meghalaya, Shillong, dated the 10th of September 2019, objection to so-and-so, in inviting reference to the letter circulated, cited here under reference, and the above mentioned subject, I am forwarding herewith a letter received from the office of the same of Maharam, Bakurwat, South so-and-so, which is self-explanatory for your kind information and necessary action as deemed fit. So this is a letter, which is issued by the governor. That's all. The governor, as your lordships have seen under 93 the power of the governor is there that if he withholds his assent and requires the district council to deliberate upon a certain issue. In this case, that is not there. And the letter, which has been followed, at what I pointed out at page 40, this only talks about, the observations made by the law department of the Governor Meghalaya. It's not by the governor. Paragraph 1, with reference to the letters on the subject cited above, I am directed to say that the law department of the government of Meghalaya, after careful examination of the bill, has made the following observations. So it is not a case, where the governor has returned the bill with a certain message, which then, was obligatory on the part of the district council that it had to be examined.
Yes, but then even then, the rules prescribe that it's be under the hand of the chairman.
Yes,
here is not so.
He has,
There's a chairman here.
I'm sorry?
Yeah, under the hand of the chief executive member.
I could not follow.
Here, in this amendment which has been resent, I think it's signed by the chairman.
It is signed by the chairman at 43 minutes.
But you know what? You see, there's a new argument here, because when does a governor himself sends a message? Well, it's any instance before.
Yes,
the governor himself sent a message.
It goes through the governor's secretariat.
Yes, but where is it? Because usually the governor acts on the advice of the
Council of Ministers. That's
Council of Affairs.
That's okay.
That's
the dates would bear me out.
The thing is that now, if the Council of Affairs has sent that this proviso has to be deleted, would it amount to the coming from the governor?
My humble submission, no. My humble submission, no. Why? I would say because it categorically points out that this is an observation of the law department. That's one, Number two, the governor, if he at all returned it, he had returned it only with the aspect of examining their objection. That's the limit.
That is why that is the culmination of the objection.
That is not the objection.
No objection has been given. Whatever objection.
No, I'll take your lordships. I'll take your lordships to what is the objection.
The message starts from.
No, I'll take your lordships.
The bill automatically.
I'll take your lordships to what is the objection. If your lordships kindly have a look at the objection, it is there. Page 29, that is not the objection. Because your lordships will kindly appreciate, that the only thing that is removed is only the proviso. And the objection, my lords, would kindly see, this starts from page 29. If my lords have it, my lords?
Yes.
May I just read? That KGTC is an autonomous office created under Article 244(2) of the 6th Schedule to the Constitution of India, and one of the most important functions of the KGTC is to protect and preserve the custom, usage and traditional political institution prevailing in various Hima and Ilaka. that the Maharam Sameship is one of the Sameships with its own unique custom and tradition, and the custom and usage was to preserve and protect by the Dorbar Hima from time immemorial. And it is a fact that Dorbar Hima is the guardian of the tradition, custom, and usages within the Maharam Sameship. That when the KHEDC codified the so-and-so CM, Deputy CM electors of Hima Maharam Act 2005 and the Maharam Sameship Administration Rules 2009, the then Executive Committee asked for consent, seek opinions, views, and suggestions from the same of and the Dorbar Hima. This was done with an intention to uphold the democratic system of governance and also to ensure that the customs and tradition is properly codified. That in the year 2014, when the KHEDC had passed the so-and-so Bill 2014 without consult and without the consent of the CM and the Dorbar Hima, the Secretary of the Dorbar Hima submitted a written objection against the amendment bills, and the District Council Affairs by so-and-so by letter dated so-and-so was pleased to return the bills. That KHEDC passed the so-and-so nomination so-and-so bill with consulting and without the consent of the chief and his Dorbar Hima. In fact, the new provision which KHEDC inserted through the amendment bills is against the land revenue and custom of Maharam Sameship.
That is the objection.
No, Milage.
That is the objection because that's saying that the rights
that is there. That continues to be there. That has not been deleted. Only the proviso, Milage, which provided only that it is, because the language of the proviso, your lordships will see that it is only for administration and not land regulation. The action done by KHEDC in passing the amendment bill without the consent and without allowing the Dorbar Hima to give its views and suggestions is arbitrary and unacceptable. It is against the democratic system of governance and goes against the custom, tradition, and land tenure system within the Maharam Sameship. In this regard, we humbly request you to kindly refuse to give your assent to the so-and-so bill. The Dorbar Hima is willing to cooperate with the KHEDC if KHEDC want to bring any change to the amendment of the Act rules of the Hima Maharam in the future in greater interest of the people. We hope you will consider our request. For your kindness, we shall ever remain grateful. Now, the Governor Secretariat, my lord, simply asks us that you kindly consider. Done, send back. Governor gives his assent. Now, the question that I'm, my lords, formulating before your lordships, my lords, is a little deviated from the facts of the case.
Because one vital, as what we see prima facie, one vital cog is missing. That, when the amendment bill was redone by the district council, it was not placed before the council.
It was not placed before the council. My lords, I have to bow down to that.
That is the only.
I have to bow down to
that. The only small.
So therefore, my lords, I formulate this question, my lords, which I would have to then answer before.
Again, validity.
Whether a law would be rendered invalid or illegal ab initio merely because there's a deviation from procedure. So, my lords, for that, my lords, I will have to take your lordships first to the Constitution. Now, the Constitution, my lords, provides for this. If I may draw your lordships' kind attention to Article 212, my lords. First 1 to 2. It's Parliament. Well, it's first, if I may draw your lordship's attention to Article 122 and it's 212. Your lordships are aware. These are the two powers of legislative powers of the Parliament and the state legislature. 122 of my lords. The language is parameter.
Not true.
The validity of any proceedings in Parliament shall not be called into question on the ground of
legislative immunity. That means, Mr. Paul, that if the act's ultra-virus also.
My lords, if it is ultra-virus, then I would have to point out, my lords, it is ultra-virus of what provision?
Yes.
Now, the case of the petitioner before my lords is merely because procedure has not been followed, my lords, it is ultra-virus. It is not his case that it is ultra-virus, my lords. My lords may correct me. Ultra-virus always has to be vis-a-vis something. Yes. It would have to be, my lords, vis-a-vis the Constitution, Article so-and-so, provision so-and-so, my lords. It is not in consonance with that particular law, so therefore it is ultra-virus. Now, your lordships, my lords, if the summation of, my lords, the law insofar as declaring some law as ultra-virus, my lords, is more or less that the two grounds, my lords. One is that there is legislative incompetence, that you could not have, my lords, legislated on a field, my lords, which is covered under some other thing. That's one part of it. The second is, my lords, violation of any constitutional mandate. These are the only two grounds on which, my lords, can then hold that a law is ultra-virus. The case of the petitioner, my lords, is not that it is not in consonance with any provision of the Constitution.
That's not inconsistent, you mean?
Yes. He also does not say, my lords, that the district council is not competent to make the law.
Right.
What he says is, my lords, that there is some procedural impropriety, if I may put it, impropriety, my lords, leading to the assent of the bill by the governor. Now, whether that per se would render the law, my lords, invalid is a question I pose to myself. And my lords, my humble submission is the law as a, my lords, and we'll try and place the authorities, is that, my lords, per se, if there is any deviation from procedure, that itself will not render the law invalid. And it is not for the courts to then inquire, my lords, that whether it is valid or invalid. That's why I took your lordship to Article 1 to 2.
Unique in itself. You see, it's not a case of, simple legislation being placed or some precedent. Here, what has happened is that it's gone once, came back, and signed by the chairman, but assented by the governor, but that piece is missing. That piece will, that's the only thing we have to address.
My lords.
How can it be overlooked?
Well, therefore, I ask the question, my lords, is whether my lords on exercise of powers on Article 226 can go to that question.
Okay, that's a valid question. Valid issue.
Under Article 122 and 212, my lords, yes. My lords, it is left to the legislative domain, my lords. Right. Courts will not inquire into that. And here, my lords, the power which is exercised by the district council is also a legislative power. There is no dispute regarding that. So the purport and the spirit of Article 122 and 212, my lords, would have to be carried into the legislative functions of the district council as well.
Yes.
You've given the list of books. Then, well, it's two authorities that come into this. Well, is I'm sorry, I don't think the list of books has been provided. I've more or less formulated what is my argument insofar as the authorities are concerned, and to buttress whatever I'm trying to say. If your lordships just give us a little accommodation, we'll try and address your lordships on this. Because the thrust of my arguments, my lords, is on this only, that two aspects, my lords, whether my lords would inquire into that, my lords, deviation from procedure, that's one. And the second is, my lords, even if there is deviation from procedure, whether that itself will render the law invalid. On that, my lords, I'll just place the authorities. Because the authorities that are there, my lords, are all on 212 and 122.
122, yes. Yes.
I adopt the argument of London Senior Counsel, Mr. Paul, my lord, so far as the question, the validity or the scope of challenge to the legislative act, my lord. In fact, my lord, if your lordship will see my counter affidavit.
Anyway, we're having it in the next date, Mr. Advocate General. So yes, you bring your authorities also.
Yes.
Mr. Chakra, so the only point.
Yes, yes, that is the core issue.
If I may, then the burden will then shift to my learned friend to get over, my lords, the embargo created under 212 and 122. He would show, my lords, that
2026 1 SCC page 1, my lord. The Supreme Court judgment has gone into this.
What does it say?
That this is a to 2026 1 SCC page 1.
2026.
Yes, my lord, this is Tamil Nadu reference matter. If you
governor's matter.
Governor's matter.
Yes, in that, this was a consultative process aspect has been dealt, my lord. That will also throw light on this issue what Mr. Paul is arguing here, my lord. Because these aspects have been considered. Sometimes files go back and forth, my lord. But when there is a formal message by governor to the assembly,
where is the formal message? If there's a formal message, that means that will.
Formal message, my lords, will then mean that the governor has, my lords, applied his mind on the law, and my lords, he feels that a certain aspect has to be examined.
Are we to say that? Are we to take it for granted that in some matter doesn't apply his mind to the law, my lords, when he returns the bills?
My lords, if it is written simpliciter, my lords, that is not the case. That's why the word message, my lords, has to be read in its proper perspective.
It's a consultative process before formally bill is returned to the House, my lord. That is the the purport of the judgment also.
We'll try and assist, my lords. This would be important.
Interesting point.
We'll have to assist, my
Let's
lords.
for further hearing
It's a
after.
very important constitutional issue. Yes, great.
Item number 10.
Highly obliged.
My lord.
Yes.
My lord, we have put to challenge over here, my lord, the show cause notice dated 39/2023 and the consequent impugned order dated 22. My lord, 39/2023, my lord. Page 25, annexure 4. My lord, and the consequent impugned order, my lord, following at page 30, annexure 5, dated 22/12/2023. My lord, I was the proprietor of an erstwhile GST firm, my lord, a firm registered under the GST regime. Annexure 1, page
30.
Page 30 is, my lord, the impugned order.
Annexure 5.
Annexure 5, my lord. May I, my lord?
Yes.
My lord, the basic facts leading up to this case, my lord. Annexure 1, page 17. I was the proprietor of a erstwhile firm, my lord, registered under the name and style of trade name of Hanuman Baksh Umadat, my lord. My lord, annexure 1, page 17. My lord, annexure 2, page 20 would demonstrate, my lord, that on the 3rd of September 2021, consequent to an agreement which had been reached between me and one Shri Suresh Kumar Agarwal, I had sold my firm over to him, my lord, and the handing taking over culminated on 31st of March 2022. Thus, from 1st of April 2022, my lord, the firm has been taken over and was being run by the new proprietor, my lord. Now, my lord, annexure 3, page 24.
1 second.
My lord.
Dealing in what business? This,
My lord, I was engaged in the business of garments, my lord.
Okay.
My GST registration will read the same, my lord, at page 17.
Okay, yes.
My lord.
So this is 3rd September 2021.
My lord, and the handing taking over culminated on 31st of March at the end of the financial year 2022. So from 1st of April, the new business entity had taken over the business, my lord.
1st April 2022.
My lord.
Yes.
My lord, annexure 3, page 24. My lord, this is the GST cancellation of my GST registration certificate, which was issued to me, my lord, on 24/1/2023 with a retrospective effect from 9/11/2022, my lord.
Yes.
My lord, see in this cancellation certificate that there is no due for which I am liable, my lord. At the time when my registration was finally cancelled.
Where is it written? No due.
My lord.
All zeros.
All zero, my lord. The petitioner, before the impugned order came to be passed, in view of peculiar facts noted above, no useful purpose may be served in keeping the petition pending or calling counter affidavit at this stage, or to relegate the present petitioner to the forum of alternative remedy. Since essential requirements of the rule of natural justice has remained to be fulfilled, we set aside the order dated 24/4/2024. The petitioner may submit his reply to the show cause notice within a period of 4 weeks from today, subject to such compliance by the petitioner, fresh order may be passed by affording opportunity of personal hearing as expeditiously as possible, preferably within a period of 3 weeks therefrom, writ petition accordingly disposed of, my lord.
Yes, Mr. Singhan.
My lord, if my lord will come to the show cause notice, my lord, that is at page number 25.
Yes.
My lord, may kindly come to page number 25. That is the show cause notice. My lord, what is the case all about, my lord? This is pertaining to ITC, which was.
See, the case is not about that they're not liable to pay GST. The case is not about, the only case is that, look, when you took out proceedings, posted to show cause, he had no idea about a show cause, and the whole adjudication happened behind the back. That's all.
My lord, that is their argument, my lord.
Yes, but is it a fact? Were they represented when the adjudicating proceedings were carried out?
My lord, it is one of the mode, my lord, under 169. It is one of the mode. It's a valid mode.
Now, firstly, is a mode of service. Secondly, is whether when you adjudicated the matter, where were they heard?
My lord, they were not there, my lord. In spite of what is the case, my lord? Just 5 minutes, my lord, if I can take.
I will give you 10 minutes, so no problem.
My lord.
Yes.
Now, the case of the petitioner is, my lord, that they have taken the ITC benefit beyond the prescribed time period, my lord. If my lord will see this show cause notice, my lord, that is at page number 25. I'll just read, my lord. Whereas on scrutiny of the return, if they have, my lord, a case, then definitely it can be, my lord, condoned and it can be referred back. But they do not have a case, my lord. It says, my lord, whereas on scrutiny of the return of MS Hanuman Box Umadat, so and so it has been notified that the taxpayer had availed the input tax credit beyond the prescribed time limit for the financial year 2017-2018. Whereas it must be noted that section 16(4) envisages that a registered person shall not be entitled to take input tax credit.
Now, it's the possible furnished reasons as to why the input tax was taken after November, after the period.
Yes.
Are there cases where the GST, whatever, has considered? What does the Act say?
Yes, my lord.
Beyond
16.
availing it beyond the.
It can be.
Then
16. If my lord will see 16, my lord.
You don't have the Act also.
Section is goods and services, central goods and similar,
Yes.
my lord. Section 16(4), my lord. It is. It says, my lord, that a registered person shall not be entitled to take input tax credit in respect of any invoice or debit note for supply of goods or service or both after the 30th day of November following the end of the financial year to which such invoice or debit note pertains, or furnishing of the relevant annual return, whichever is earlier, provided that the registered person shall be entitled to take input tax credit after the due date of the furnishing of the return under section 39 for the month of September 2018 till the due date of furnishing of the return under the said sections for the month of March 2019 in respect of any invoice relating to such debit note for supply of goods or service or both made during the financial year 2017-18, the details of which has been uploaded by the supplier under subsection 1 of section 37 till the due date for furnishing of the detail under subsection 1 of the said sections for the month of March 2019. So by this by the second paragraph, the time period, my lord, as per the section 16 clause 4, my lord, the time period is up till
November.
Yes, my lord. It will be up till 24/2019 because it says of the said sections for the month of March 2019. So the next will be, my lord, 24/2019. So as per section 16(4), they could have filed till 28/4/2019, my lord. But what has happened, my lord? They have filed it on 25/7/2019 and 3/12/2019. As per the provision of the law, my lord, they were not allowed to take the benefit, ITC benefit, beyond that period, my lord, that is 24/2019. Now, what has happened, my lord? After the Finance Act, my lord, 2024 has come. My lord, may kindly see my affidavit that I have enclosed. The Finance Act. That is at page number 19, my lord. Page number 19, my lord.
Yes.
Page number 19 of my affidavit.
Yes.
This is the Finance Act 2024, my lord. If my lord will see the next page, page number 21,
Yes.
section 118.
Yes.
Section 118, it says amendment of section 16. In section 16 of the Central Goods and Service Tax Act with effect, this is the what I have read out, my lord. In section 16 of the Central Goods and Service Tax Act with effect from 1st day of July 2017, after subsection 4, the following subsection shall be inserted. That is, notwithstanding anything contained in subsection 4 in respect of an invoice or debit note for supply of goods or service or both pertaining to the financial year 2017-18, that is the relevant year, my lord, the registered person shall be entitled to take input tax credit in any return under section 39 which is filed up to the 30th day of November 2021. So the time period for availing the ITC benefit was extended by Finance Act.
Then
thereafter, my lord, the provision was laid down how these benefits can be availed.
let them go before you.
My lord, may kindly see the provision which was laid down, my lord, that is a notification.
See, one thing, Mr. Singhon, every finance act, GST keeps on getting amended. Now the show cause, in fact, might become, it might become redundant also.
Only one
It's
page, my
redundant
lord.
because why? With amendment has come.
No.
So apart from time,
Absolutely not, my lord. Only one page, my lord, will see page number 61.
You hear them.
That is, my lord, if my lord will see page number 61, that is the crux of the case, my lord. Paragraph 2.
See, you hear them, even if it's a formality, you hear them in past order.
My lord, may kindly, only 1 minute, my lord, I will take, my lord, I will take your lordship to page number 61.
Only case is that service
page
of
number
notice has
61,
to be
that is the
meaningful and
relevant
not
page, my lord,
symbolic.
for the entire case. Page number
Yes.
61.
Of the affidavit.
Of my affidavit, my lord, page number 61.
Okay.
Page number 61, paragraph 2, my lord.
Yes.
Paragraph 2 said, the said person shall, it is pertaining to, I will just read the first paragraph also, my lord, it will be relevant. In exercise of the powers conferred under section 148 of the Central Goods and Service Tax Act, so and so, on the recommendations of the council, hereby notifies the following special procedure for rectification of order to be followed by the class of registered person against whom any order under section 73, that is the order which have been passed, my lord, has been issued confirming demand for wrong availment of input tax credit on account of contraventions of provisions of subsection 4 of section 16 of the said act, but where such input tax credit is now available as per the provision of subsection 5 of subsection 6 or subsection 6 of section 16 of the said act, and where appeal against the said order has not been filed, namely, the said person shall file electronically on the common portal within a period of 6 months from the date of issue of this notification an application for rectification of an order issued under section 73 or under section. They were supposed to file within the time period, that is 6 months period, my lord. If they would have filed it, my lord, the benefit could have been extended, but they have not filed. So in view of this notification, my lord, now they cannot take the benefit, my lord.
They stop.
They are stopped, my lord.
Right.
They cannot.
We'll pass order this.
All right.
My lord, there is just one thing, if I may permit. Lord, I have come for national justice. The service of notice cannot be symbolic. My friend is going into merits.
Section 169, my lord.
There is a new notification of 15th
valid mode
October.
of service, my lord.
There is a new notification of
Email
15th.
and portal. Yes.
There is a new notification of 15th October which saying that I am eligible for that period.
They were otherwise eligible, my lord. But
They
they
still
should have
eligible.
claimed it within 6
See,
months
we'll
period, my
not
lord.
get into interrogates anything else.
Highly obliged.
Any mention?
May it please your lord. My lord, I beg to mention item number 36. My lord, Mr. Philemon Nongri is out of station today.
Who?
Mr. Philemon Nongri is out of station. If this matter may be taken up in 2 weeks, my lord.
You're the other side. You inform them.
I've informed Mr. Goyal, my lord.
Mr. Goyal?
Yes, my lord.
Right. Yes.
Much obliged.
Much obliged, Your Lordship. May it please your Lordship. I'd like to make a mention of item number 24.
Yes, for the other side.
Lordship, I pray this matter to come after 2 weeks.
What's the matter about?
This is a selection and appointment matter, Your Lordship.
Yes.
No objection, Your lordship.
Yes.
Much obliged.
May I please, your lordship? I beg to mention item number 25, my lord.
Why?
My lord, the conducting counsel is having some personal difficulties, my lord.
The same matters, those linked matters.
Yes, my lord.
Why?
We are 25 to 35, my lord.
Why you ask for time also?
No, your lordship.
You're not asking for time. You don't ask for time, then it'll cover their case also. Same subject matter.
Up at the same time, and
Yes?
her senior is leading the matter.
You are there, both of you argue.
My lord, I'm seeking some time, my lord.
Okay.
Maybe the
Small
last
matter, right? What's the matter about?
the service matter, my lord. Service matter.
Legalization.
Yes.
No, my lord, this is a matter where they have not applied for advertisement. If your lordship would recall, the advertisement was issued, they did not apply for advertisement, and these are the 10 connected matters, my lord, from the district committee, so if your lordship would recall.
What to do?
Subsequently, there was a cabinet sitting to this effect.
There is nothing, no cabinet
was
issue
supposed
in
to
this
take
matter.
some instructions.
After 1 week is a fixed matter.
Yes, my lord.
As is submitted that the leading counsel which are not available in these matters, just after 1 week as fixed items. Yes. 25 to 35.
Yes, my lord.
25 to 35, my lord.
Okay. Yes. Yes.
May it please your Lordship. Lordship, I beg to mention item number 23, my Lord, on behalf of Mr. H. Karmalang. My Lord, can you have the matter after 2 weeks, my Lord? No objection, Your Lordship. Evening.
Lordship, I'd like to mention item number 38, Lordship.
Nothing is gone. There are no hearings today. Yes.
Lordship, praying for 2 weeks time, Lordship.
38.
38, Lordship.
And?
That's 38 only now.
And? 38 and what? That's it. No objection.
No objection.
Yeah. 39?
39, Lordship.
39 also. Then what about 40 and 41?
No, Lordship.
41?
No, Lordship. We won't mention. Obliged, Lordship.
37 also? Yes. No.
Supplementary this item number 1.
My lord, this is again the same Shillong to Dauki Road.
Stretch.
Yes, my lord, there's the same stretch, my lord. And the Pirusla Wakadite stretch, my lord.
Heard Mr. President, you should notice. When's the matters coming up?
On the 1st, your lordship. 1st of April.
Preferable 1st April. MS Donkey is present on behalf of
124,
response number
your lordship.
124. As per plan, except notice 124, no for notice respondents. But you should take steps for issue the notice to respondent number 5 and 6
5
in 2 days.
My lord. Obliged.
That's accordingly.
Item number 2.
Page 28, Annexure 6. According to the petitioner, my lord, the said discharge was not voluntary, though it is said to be at his own request, my lord. That is the limited issue, my lord.
Heard Mr. B. Pathak issue notice tenable in
3 weeks.
3 weeks. Dr. Mbozika with MS C. Jala is present on behalf of 123 no current is required. Lists accordingly on so and so. Yes.
Item number 3.
My lord, item 3 pertains to promotion. My lord, this petitioner is the trumpet player in the Assam Rifle Band. He developed trumpet player, my lord.
Okay, yeah.
Instrument, my lord. He developed some bronchital issue because of constant playing, and because of that medical reason, his promotion was denied, my lord. And our case is that it is attributable to duty, and therefore should be considered, my lord.
Yeah, Dr. Mbozika, how can you, he's a trumpet player. If he's got bronchial issues with a play the trumpet, then naturally you can't say that will disable him.
Only promotion will I'll have his term. I'll have it.
Same order.
Obliged, man.
Daily list item number 1.
My lord, the notices on the respondents are completed, my lord.
Where 3, 4, 5, 6, and 7? 3, 4, 6, and 7.
Yes, my lord. And
who's
on
appearing for 5? You are. Appearing for whom? You are?
For the state respondent.
What's the respondents? Five is served.
My lord, it's been served, my lord. My
1 and 2 appearing. Then 3, 4. What about number 5?
5 is the 5 is one Emma Tariang. I think this 5 affidavits. We have filed an affidavit, my lord, to this under number 5. Just some.
Yes.
My lord, kindly see order dated 4th of February, my lord. Office note indicates that though service is complete on respondent number 5.
Okay.
So that's complete, sir. And now the others also, my lord.
None are appearing.
None of them have appeared.
4 to 7.
My lord.
You have any objections to the review?
Your Lordship, I'm appearing on behalf of E.H. Karwan Long, Your Lordship.
Then?
I haven't received any instructions, Your Lordship.
Review, my lord, there's just one manifest error apparent, my lord. There's one only because my lord has passed an order, my lord. Section 63 of the Land Acquisition Act very clearly says that it is a bar on the civil court, my lord. My lord was of the view that since there was a disputed question, first of all, my lord said there's a disputed questions, my lord, and relegated us to the civil court, my lord.
Yeah.
So now, because now that is a statutory bar. So
what matter about?
My lord, this a land acquisition matter, my lord, of the expansion of the Omroi airport, my lord.
And let Mr. Kharanang come and dispose of my case.
My lord.
Yes, none appears on behalf of the respondents. 3 to 7. Though it is recorded that they have been served from MS Nongrum. Praise that matter the date as the Arguing Council for the state is not present. This of 6 weeks, yes.
Item number 2.
Please, Your Lordship. Lordship, I'm praying that the records may be called for, my lord, here in this matter. It would be necessary, my lord.
Will produce milk. Some time may be given to me. Some time will be required.
Yes, party submit that the records are necessary for proper adjudication of the matter. Accordingly, call for the records of. Give the.
Yes, my lord.
Appeal petition.
My lord.
That revenue 38 AC.
Yes.
Two records would be required, my lord.
According call for the records of
38 AC of 2023 and 39 AC.
GHADC, GHADC, REB slash 38 A capital stop C capital of 2023 and GHADC revenue slash 39 AC same. And also appeal petition, JAC appeal petition number 65 AC of 2024 from the office of the respondents.
Hello,
just after receipt of the records.
3.
Lordship, we have received the affidavit filed by the state. Lordship, we may be allowed some time to file the rejoinder, Lordship.
Yes, as per 2 weeks time allowed for rejoinder.
In the meantime, may I file an additional affidavit?
Why? For what?
To bring and record the birth certificate of the children of respondent 5 and the deceased husband.
So rejoinders also MS Kharmandai for respondent number
5, Your Lordship.
5. Also prays that she will be allowed to bring additional effort, find additional to bring and record the age of the
birth certificate.
The birth certificates of the children. Children respondent number 5. The prayer is allowed, yes, just after 2 weeks.
Obliged.
Right.
4.
But this is required to file an affidavit. This is out of station, my lord.
Who?
The director is
complied.
But it is in the process of complying, my lord.
My lord, after one year, more than 1 year has passed, my
There
lord.
is some delay, my lord. But
My lord, 4th November order is quite clear, my lord. My lord has said that before that compliance order should be there. He's 80 years going to be, my lord.
he came to court also after 30 years.
My lord, that irrespective of if the order would is they are not satisfied, they could have
in 1 week positively. Yes.
highly.
Just thereafter we'll pass orders.
5.
I'll respond file in 1 week positive. Yes.
Lordship, we have received today the affidavit filed by the GCDC.
Yes. So 1 week rejoinder you want? No.
Yes, Lordship.
2 weeks time as per allowed for rejoinder to affidavit filed by the respondents.
Obliged, Lordship.
6.
May I please option?
What authorities? You got authorities?
Lordship, I'm praying for a week's time, Your Lordship.
Why?
I'm praying that the matter may be listed for hearing after a week, Your
What's the
Lordship.
matter about?
Your Lordship, here we are challenging the recruitment process for the post of.
Now, why would the court ask you? Why do you want time to look for authorities last date? That's on 26/2.
Your Lordship, in the meantime, we'll look for authorities and the conducting
Why?
council.
What authorities? What was the law point involved?
Your Lordship, here the petitioner mistakenly take no in the MR sheet, Your Lordship. He's a spot person, Your Lordship. And we are trying to look for authorities, Your Lordship, in support of our case, Your Lordship.
Was you ticked it yourself? No,
Yes, Your Lordship, but it was a bona fide mistake, Your Lordship, on our part.
Okay, 1 week on the prayer of also GC Marbo.
7.
Is Marbo or Mirabo?
Marbo, Lordship.
What's the difference in Mirabo and Marbo?
There's no difference.
No difference. Only spelling.
Yes, and
7.
Your Lordship, I have taken step, Your Lordship.
Lordship, I'm appearing on behalf of respondent, Lordship.
Very good. So?
Yes, Lordship.
Your Lordship, I humbly pray that the interim, Your Lordship, may be considered because it's very difficult on the part of the appellant, Your Lordship, to survive on that remaining balance. Your Lordship.
Let's see where's the order.
It's at page 21, Your Lordship.
It's registered as a FEO, correct? No?
Yes, Your Lordship.
Yes.
Lordship, I have not received any instructions from my client, Lordship. So time may be given, Lordship.
You've got a copy of the appeal memo?
Yes, Lordship. Today we have filed our powers.
Give him 1 week's time.
Lordship.
Mr.
P. Ghosh, Lordship.
P. Ghosh has an appearance in behalf of the sole respondent. As such notice, will respond and praise allowed 1 week's time to obtain instructions. Yes, we have called for the request. Meanwhile, a call for we won't call for the request. Just see and tell him first. Just after 1 week, yes.
Oh, bless, Lordship.
8.
Please, Your Lordship, and for respondent number 2, Your Lordship, I just need 2 weeks time, Lordship, to file an affidavit.
Your Lordship, yes, Your Lordship. Actually, Your Lordship, kindly consider this urgency in this matter, Your Lordship, because the
What's
petitioner,
the
amount is
the illegal transaction is 4,900.
4,900.
So because
That
of
is the
that,
issue.
the entire account has been
Secure
freezed.
amount and defreeze the account.
Yes, Your Lordship. That is my small prayer,
As Your
actually.
Lordship is aware, there's the judgment of Your Lordship had referred to that Kerala High Court judgment where some verification is required if some authority, because we had acted on the direction of the authority.
Whatever it is,
cybercrime.
you secure amount with the disputed amount and then you defreeze the account.
So if the concerned authority gave us a clearance, then only we will.
Who will give clearance?
The cybercrime. If they can give us a clearance, that's it. They
Which
respondent
member
number
state?
3. Respondent number 3.
Yes. Number 3. What instructions do you have?
Lordship, the conducting counsel, Mr. H. Abraham, and he's been defeated.
Call him right now. Call where Mr. Abraham?
He's on next month.
Affidavit as it is ready. We just need time to file it here. We've sent it for vetting.
No.
Because in the writ petition, nothing is clear. The correspondent, certain letters that we issued to the writ petition, that was not enclosed. It's there. Emails,
Regarding?
the correspondent from our side to them. That is not been disclosed in this writ petition. We would like to
The
bring
amount is
this.
very meager. How then?
But that is the direction that we received, that we need to freeze this amount.
Your Lordship, just because of 4,000 and his entire
And
account
the
has
account
been
of
frozen.
34 lakhs has been
And
frozen.
he's solely relying on this account,
There
Your
is a
Lordship, for
reason for
livelihood
that.
and
There is a
business.
sufficient reason. That will bring by affidavit here.
What is the reason for freezing the entire amount?
That the affidavit, Your Lordship, you can speak. I don't have the affidavit right now. When we file the affidavit, everything will be clear, Your Lordship. There are correspondent,
And how do you file an affidavit without anything being clear then?
everything
have
is clear in the affidavit. I don't have it right now, Your Lordship. That's why I need time to just file that affidavit.
Show your draft affidavit. What do you have written?
I don't have it
Well,
right now, Your Lordship.
what do you
We've
mean you
sent
don't
for
have it
vetting.
there?
I am not instructed to disclose.
You can't
after
disclose
it's-
to the court.
No, it's not that, Your Lordship. It's been sent for vetting, Your Lordship. After it come back, we'll file it, Your Lordship. Positively, give us just 2 weeks time, Your Lordship.
No, not 2 weeks. Give you 1 week's time.
1 week will be too short. It has gone all the way to Calcutta.
Doesn't matter. Send a special messenger.
At least 10 days time.
Yes, Mr. S. Marpan, please. They will allow further time to find affidavit stuff. It is noted that the matter concerns the freezing of account of a meager amount on the basis of a disputed amount, which is very meager, of only
4,900.
4,900.
Yes.
So, after we file possibly within 1 week. Yes. Yes, thereafter.
9.
Much obliged, Your Lordship.
9.
My lord, item number 9 to 14, 9 to 14, and then again 16 to 19, my lord. These are all connected matters.
What is the matter about?
My lord, this is Social Welfare Department, my lord, regularization matters, my lord. These are.
Yes, MS Bank.
Yes, my lord. My
Where's
lord,
affidavit?
I'm still waiting for instructions, my lord. I have sent correspondence. We're waiting.
Yes, as great further 2 weeks time allowed for affidavit.
My lord. How like?
All these matters. 9 to 14, 16 to 19.
Yes,
Yes, my lord.
15.
Please, Your Lordship. I'm still waiting for the instruction, Your Lordship.
When was the file, the matter?
19
It's a fetch matter.
Lordship.
Where's Mr. Sheikh?
It's in court number 1, Your Lordship.
Where's Mr. PT Sama?
He's
So you'll
also
argue
in
the
courtroom
matter.
number 1, Lordship.
Mr. Pala. Let counsel want to please submits the instruction to be received. At least after 1 week, yes. Inasmuch as Ms. S.C. Sheikh was produced an inquiry report today. Yeah. Yeah.
20.
May I please, Your Lordship? Your Lordship, we are yet to collect a notice, Your Lordship, to be issued to respondent.
Why? Yes. Your name?
Didi Funken. Didi Funken.
MS also submitted due to inadvertence. The steps going to be taken for issuance of notice on the respondent 5. So,
We're awaiting instructions, Your Lordship.
Yes, she pays for the allowed 2 days time to take steps. Next part, Amazon Inquiry pays for the allowed further 2 weeks time to file affidavit. Yes.
21.
May I please, Your Lordship? Your Lordship, I am appearing on behalf of J. Thapa. Your Lordship, the service is not complete on the respondent number 6, Your Lordship. So I'm praying for some time, Your Lordship.
Private respondent.
Yes, praying for some time. You've taken steps when?
I'll take it by today, Your Lordship.
Not taken steps? Yes, today also. Your name?
SD Sangma, Your Lordship.
MSS's number submit same thing. Due inadvertent steps gonna be taken for service of risk on the 6th. Keep it for 2 days time. And you affidavit. Mr. N. Sincon pays for the 12 time for affidavit.
Highly obliged, Your Lordship.
Hearing 22.
Yes.
May it please, Your Lordship. Lordship, this matter pertains to dumping of soil in my agricultural land, and by the order dated 4/4/2020-25, Your Lordship was pleased to direct for joint inspection. So, joint inspection, the report has already been filed, Lordship. Joint inspection report. And kindly come to Lordship, the page 3 of the joint inspection report.
It's filed affidavit.
Yes, Lordship. I think I have received like this, Lordship. I do not know whether the state has filed.
Okay.
So, page 3, Lordship.
Yes.
Lordship, I may be allowed to read the relevant parts. The following points were raised and discussed.
Where reading from?
Sir, Lordship, the important relevant points. Page 3, the
page
following
3.
points. Yes, Lordship. Page 3.
Okay. Yeah.
The following points were raised and discussed. As per statement by the petitioners, they stated the implementing agency had dumped the soil into their cultivated land several years ago, whereby it destroyed their crops. As per statement by NHIDCL, they stated that the soil was dumped several years ago at an adjacent location. However, due to rain and erosion, perhaps this soil eroded to the lower areas. As per ground reality, there seems to be instances of previous damages to land and crops. However, due to lapse of time, it was observed that there were broomsticks and other vegetations were growing.
There was no quantification by Agriculture Department something done with damage.
No.
Then?
Because of lapse of time, my lord, the photographs are there, my lord. The broomstick cultivation is still there, my lord.
No, we can't go by photographs.
Lordship, in the report it is stating that it was observed. I have not started cultivating. It was observed. If I had started cultivation, then they would have the inspection. The report would have come.
What is it? Observed?
Observed. Just observed.
That
the broomsticks were there and other vegetation. But Lordship, what vegetation was there is not mentioned. However, Lordship, when the land was,
they grew by themselves, or you have to?
Yes, Lordship. Even when I filed this petition, I have annexed those photographs. Even at that time, also broomsticks were there.
So, what damage has been caused that you seek a compensation?
Lordship, my crops has already been destroyed.
What crops?
Like Lordship, I have stated in my petitions, I was cultivating.
Any signs of the crops growing earlier?
Lordship, I was cultivating like broomstick, betel nut, jackfruit, pineapples, all those. Orange trees were also destroyed, Lordship.
No, but upon the report, does it say that it appears that earlier on there were brooms or there were orange trees and
Lordship, that is Lordship. It is not that. That has been destroyed. So that has not been inspected nicely, Lordship.
See this, as per ground, the same insufficient damaged land and crops. However, who's this person who did the inspection?
At page 3 itself, it shows El Kharman, MCS Assistant Commissioner, Peninsular Subdivision, along with representative from the concerned line department with the petitioner, Andres Kumset and another one.
Your Lordship, if I may interject, the matter is being led by Mr. Shulai and he's on legs in court number 3 with the partner matter. Your Lordship, I pray that matter may come at the end of the board.
This court is not free today, it'll be rising soon. Yes.
Mrs. Lordship, it is an admitted position from the NHIDCL that the
might be admitted, Mr. Deb, but admission should be on certain categorical, observations. That yes, there was land had slipped, and then like the trees of the petitioner amounting to maybe 20 orange trees, so on and so forth, have been destroyed, and so quantification of damage was done. Anyway, as I submitted that Ms. Andy Shulai is not available, just after 1 week. Try to get some, but then authorities also, but then there's a very vague report, Dr. Mojika.
37.
Actually, there is nothing. On the ground, everything is there.
37.
Yes.
Please, Lordship. Here, Your Lordship, initially, the petitioner here was appointed as peon, Your Lordship. And thereafter...
You're there.
Your Lordship, as Anne, she's...
Where is it?
Should be appearing.
You have to stop this online hearing. Except for certain councils, is creating more obstacles than
The matter may come after something, maybe back to 1 week like that.
The Army Council, because is not available just after 1 week. You engage, where's the answer? Engage other councils. Government panels become absolutely.
40.
Yes.
I'm appearing on behalf of B. Kumar. The conducting council have some personal difficulty. I'm praying for a short accommodation.
For 2 weeks, yes.
Highly obliged.
What 41?
May please, Your Lordship. Your Lordship, this is a writ petition challenging the...
Before my learned friends start, there is a order where order dated 04/2026 where there is a record is supposed to quote for this one. Yes.
Where's the records? Where's the records? Why are you doing like behind like that? Don't do that. See, my senior's coming. Records have come.
No, my lord. I need some time because of.
Where's because of the trouble in Garwils?
My lord. And district council was also closed down for a few days.
Which order is that?
Order dated 04/2026, my lord.
If my lord may kindly allow me some more time, my lord.
Yeah, please record the order dated 4/12.
Your Lordship, Lordship, we have filed the affidavit.
No, where's the order dated 4/12?
Lordship, we had filed the affidavit on the 25th, Your Lordship.
No, what order was passed in that 4/12?
Your Lordship, in
affidavit filed when?
25th.
25th. Okay, yes. I don't see. What order is this? What do you say record, Mr. Sangma? It is for record, only for them to place on record. What impact will this order have?
Your Lordship, we had withdrew the appeal before the CM, Your Lordship.
Oh, that's a proceeding for this court.
Yes, Your Lordship. And a copy has already been served, Your Lordship, to the respondent.
So you've come here straight against order of EM and child revenue?
Yes.
Why you want to bypass EM?
Your Lordship, since there is an order passed by the Honorable Guwahati High Court in the year 1996, Your Lordship, where the matter has already been adjudicated, Your Lordship, regarding, Your Lordship, the petitioner belonged to the Sakagri Aking, Your Lordship. And in that order, Your Lordship, the matter has already been adjudicated, Your Lordship, regarding the Sakagri Aking, Your Lordship. The private respondent, Your Lordship, belonged to the Baladingiri Aking, Your Lordship.
But the statute provide appeal. This is the same ground my friend can take before the CEM. What? Because the statute, my lord, can the statute be overcome by filing a writ, my lord?
And Your Lordship, if we come to the impugn order,
which page is it?
Annexure 6, Your Lordship, page 98. Your Lordship, the CEM, Your Lordship, have kept the order of the Honorable Guwahati High Court in silent, Your Lordship. In this order, Your Lordship, he have never mentioned, Your Lordship, the order of the Honorable High Court, or Guwahati High Court, Your Lordship.
This is by the entire land revenue?
Yes, my lord.
What prevents you? Why can't you bring the notice of CEM? With order of the Guwahati High Court, it says that you shouldn't go to CEM.
They think that the matter is already at finality on the basis of the Guwahati High Court's order.
Exactly, so that you should show the CEM.
They should show the CEM, and moreover, my lord, if my lord may kindly see the EM's order. If my lord may kindly see the EM's order, this is not a final order, my lord. My lord may kindly come to 1171, my lord.
No, for their what do you call it, grievances, that there's no question of doing anything afresh. The matter has already been decided. That's the only case they have.
If there is a law and order problem, my lord, and there is a dispute between the Aking or the Nokmas, just a minute. Then, my lord, someone rightly filed an application before the EM, revenue in charge, my lord. Now, EM has not decided the matter, my lord, or not declared that Mr. A or Mr. B is the Nokma. They say to maintain status quo.
Correct.
Your Lordship, Sakagri, Your Lordship. Separate Aking from the private respondent, Baladingiri, Your Lordship.
No orders been passed in favor of Sakagri.
Yes, Your Lordship.
And then that order has been upheld by this High Court also.
Yes, Your Lordship. Your Lordship, the private respondent, only when on the death of my predecessors, Your Lordship, I had filed an application for registration of Nokma. Then only, Your Lordship, the private respondent had filed an objection regarding my registration, Your Lordship, regarding Sakagri registration, Your Lordship. And Your Lordship, it's pertinent to mention, Your Lordship, they have never challenged the order of the Honorable Guwahati High Court, Your Lordship.
So the order of the High Court? I don't know what is the matter now. Are you sure?
Annexure 4. No, Your Lordship.
Sakagri is very familiar name.
Annexure 4, Your Lordship, page 72.
Sakagri. Yeah.
Your Lordship, the operative part is at page 87.
Will disposer of asking your EM to, understand the fact that, they examine the order of the High Court and whether this is necessary or not for them to go for inquiry.
My lord. But only thing is this.
But you have to go to CEM.
For that, my lord, they have to go to the CEM. And my lord,
why you would do the appeal? On whose advice? So the only thing you have to do for the appeal also, that the order is probably wrong of the EM in charge revenue, because he's asked for re-inquiry or something.
Yes, yes, Lord.
So without examining that is
Yes.
like as you are submitted, it's already a settled position.
Yes, yes, Lordship.
That's the thing. You take instructions, you will have it again. Otherwise, you remand it back, and with specific directions that the CEM will take up the appeal, will restore it to file, and then it shall be restored to file. Then take cognizance of this order.
My lord, if my lord may kindly see 169, page 169, they are not deciding the Nokmaship, my lord. Page 169, if my lord may kindly see the order dated 7/3/2020.
No, apprehension, you see. Out there, anything can happen with the day.
My lord.
Or even not challenging Nokma, suddenly they might just change the Nokma. So,
only thing is this application was filed.
Sama is there.
Lordship,
There is the worry part,
Lordship,
Lord.
This in my affidavit in opposition, which I have enclosed it.
No, what do you say? This 169?
169, if my lord may kindly say, for this 169, it is not about a Nokmaship or anything. It's about deforestation, my lord. But let me kindly see the first paragraph of the order. The petitioner so-and-so has filed an application under the spirit of order so-and-so, which read with section so-and-so, seeking a temporary injunction against the opposite party so-and-so and others. The petitioner alleges that the opposite party is engaged in deforestation, destruction of natural resource and unauthorized land occupying within so-and-so Aking, my lord. The petitioner contended that the opposite parties attempt to establish
No. Now this is which historical pause. This is case. They are trying to usurp the Aking.
So they are trying to deforest the Aking, my lord. Against this, my lord, the order was passed.
But even CC 17 to ensure neutrality and prevent for disputes, the administration of Sakalgiri shall be placed in custody of Secretary JDC.
Yes.
Now still under custody of Secretary JDC.
Yes, yes, Lordship.
Then we'll have to hear this urgently. You take instructions. That's all right. It's over, yes.
Phone isn't working, so
Yes.
I haven't been.
After, yes.
Madam, Mr. Sangma is there if you
So
would like to hear.
whether record will be required, my lord, I don't think so, my lord, record is required.